What is up? Welcome to the Docket presented by Defense Diaries, where we will give you just facts every single time. I'm Bob Mata, your host, and this is my fabulous wife, Allison. I don't know. Why are you so small, girl?
Hold on. I don't know. It looks different than it did before because I'm signed in as, oh, well, then I guess it was something you did.
It's definitely something I did. Welcome to the show, my brilliant, beautiful co-host. How are you?
Pretty good.
All right. So you've been working, real job. I've been creeping around the true crime world per usual. A lot of stuff going on with Delphi. Every time I think I'm out, they pull me back in every single time. It's crazy. It's just like nonstop with that case. Just want to give a few other updates. If you don't know, Mama murderer Donna Adelson was arrested this week. Charlie Adelson's mother, same exact charges that Charlie was just convicted of. They picked her up at Miami-Dade, and she's going to go down same way that Charlie did. I anticipate that fully. Trial's going to be different. There's different elements, but it's not going to be identical to Charlie's trial. So it'll still be interesting. Are they going to get Wendy anytime soon? We'll find out. I mean, if we're looking for full justice for Dan Markel, I think Wendy's got to go down as well. What else we got? Tim Ferreter sentenced today. The boy in the box, the guy who built the just incredibly weird box bedroom in his garage that had no windows and kept his kid in there for extended periods of time over months. He got 5 years. 60 months today, plus 5 years probation. And I think he's going to have to register on, an abuse to children list, which is frankly worse than jail, to be honest with you. Any of those lists that you have to register for, whether you're a sex offender or you're abuse to children, those things haunt you like they never go away. If you travel for 3 days, you got to register everywhere you go. It's serious punishment. So dude's going to be feeling that one for a long time. What else do we have? Caitlin Armstrong, guilty. So that was good to see. I mean, why she went to trial, I'll never know. Her consciousness of guilt stuff with escaping and traveling out of the country and the plastic surgery and just all of it. Like that thing was a foregone conclusion. They may not have made her an offer. Like that may have been why she ended up ultimately not pleading out on that. I don't know. But I was surprised she went to trial and I sat there and watched that defense attorney try to explain all of her actions after the fact away. And it was an impossible task. So looks like we lost Allie. I think I have her trying to switch to a different computer because that one she has, I think it's choppy for her. So, but what y'all are here for, what I'm really here for, is we got more Delphi action. The case that just never sleeps, still rolling. It is intensely rolling at this point. So as you guys know, essentially where we left off, I think on our last live was like the last, the last action that had taken place was that the second original action was filed seeking, the three big things: one, to get Gull off the case; two, to get Rosie and Baldwin reinstated; and three, to stay the trial, meaning that they delay the trial down at the trial court level until this all gets sorted out. That's kind of a big one. I was actually hoping, if they're going to take a while to rule on this, that would be something that maybe they would, if they're seriously contemplating bringing Rosie and Baldwin back, I think it would behoove the court, the high court, to put a stall on what's going on in the lower courts. It would just make sense in the sense that, it'll get very confusing. Say, for instance, when we get into the order, so I'm going to start chronologically with what happened recently, but, and it's going to start with the order that Gull dropped. I believe that it was on the 14th in anticipation. It might have been the 15th. No, it was the 14th. But, if these guys don't adopt the memo and the Franks hearing and they decide to go a different route, and then the Supreme Court says, okay, you know what? We agree with the relator. We're going to reinstall Rosie and Baldwin. Then we've got kind of a cluster F, worse than it already is now. And it's pretty bad now. So, all right, without further ado, hopefully Allison comes back in the near future. But let's start cracking, because I'm not going to try to keep you guys here all night. All right, first thing I want to look at is the order of the court. Okay, and this particular document was prepared by Gull on the 14th, obviously in anticipation of, her having to have her response on file today, which she did get done in a timely fashion. I'm going to read through this one. When we get to her response, I know a lot of you jumped over from criminality. So Teresa, thank you very much for kicking people over. I know some of you may have came from the Shaming of Jay, where you got to hang out with Sunny Slaughter, who's an amazing woman. And I know some of you came from my boys over at Publicly Buzzed. So welcome to all of you. I love all of you. If you guys are from Grizzly, I love you guys too. I love everybody, basically. Well, I love everybody that I love. So, all right, let's dig through this order. So again, this was done in anticipation of the response coming. This I am going to read through. So the court has recently reviewed the chronological case summary. Okay, that's the CCS. So whenever you're seeing that abbreviated in all the documents, that's what they're talking about in this cause, and notes that the clerk of court has not yet made available to the public on the CCS the 118 documents previously made remotely accessible by court order of June 28, 2023. So immediately, as soon as I read this, I knew that the judge was completely throwing the clerk of court under the bus. She has now officially, in the first sentence of this order, shifted all the blame directly on the elected clerk of court, saying, hey, look, I told you to do this. I put it on a website, and it was your job to do it proper. And I'm shocked. I'm shocked and mortified to see that those 118 documents still aren't on the docket. I can't believe it. I can't believe it. So, completely disingenuous, in my opinion, that her saying that she didn't realize that they weren't going to get transmitted to the CCS is completely disingenuous on Judge Gull's part. It was very clear they were creating this website in order for all of us to go over there and struggle to get the documents. I mean, if you're like a millennial and you're super dope with tech, I mean, it was probably no problem. If you're like an old fart bag like me, man, it was a struggle. I had a tough time, and it was not easy. I had reporters that I'm asking, hey, can you send me the shit? I mean, it shouldn't be like that, So it was difficult for me to get on there. So the court previously created a website for these documents as a convenience to the public and the clerk to ensure the public had prompt remote access to these documents. The clerk is now ordered to enter these documents on the CCS forthwith. Good legalese there. Good legalese usage by the judge. The clerk is further ordered to unseal the June 20th, 2023 filing by the Carroll County Sheriff and the July 5th, 2023 letter from a Department of Correction inmate and place the same on the CCS. And I've got both of those. The affidavit, and it wasn't really an affidavit. People kept calling it an affidavit. It was just a filing. It was a transfer filing by the sheriff. I'm not going to bother going through it because, frankly, it's boring, and there's not much to it. And it relates really to what was going on with the inmate that we are going to review that letter because it's interesting. I don't know that it's all relevant. It's certainly relevant as to what's going on in Westville with some of these other inmates. And he certainly mentions Rick Allen a couple of times in there. And he seems that he was privy to some of the abuse that Allen was suffering. And, you know, he talks about the fact, well, we'll get to that. The court further notes that a motion for a Franks hearing and accompanying documents filed by former attorneys on September 18th, 2023, including the Franks motion, the memorandum of support of motion, and the exhibits list, are marked as confidential on the CCS as counsel failed to supply a redacted version at the time of filing. Okay, on October 31st, 2023, the court ordered defendants' new counsel to review the pleadings and the discovery and to either adopt those pleadings or make their own. Now, if counsels adopt the same, they are ordered to file a redacted version of the pleadings. What does that mean? We don't know. We don't know what it means. Not at this point. On the 14th, when she says this, we don't know. We find out what she means when we get over to her response to the original action for the writ of mandamus. If defendants' new counsel inform the court that they intend to pursue the Franks motion, the court will schedule a hearing. Finally, the clerk is ordered to place and make accessible on the CCS former attorney's pleadings of October 25th, 2023 and October 26th, 2023. So that is going to be Rosie's motions. Okay. So obviously he filed the motion to DQ Gull, and he also filed his verified notice that he still considered himself to be counsel for Richard Allen. Here's, and here's where if she would have written this language originally, instead of pulling this off of the docket in terms of Rosie's filings, that probably wouldn't have been an issue. So she says, as noted in the prior order, which was the backdated order, the one that she didn't sign for weeks after the 19th. And then as soon as the day after Rosie files his pleadings, she then backdates the order. They call it nunc pro tunc. And at that point, she enters the order. As noted in the prior order, the court considers these pleadings stricken from the record and will not consider those pleadings as the attorneys who filed same are no longer of record. All right, so that's her order. So that drops on the 14th. It was moderately interesting. And at that point, I'm like, okay, well, she basically just mooted the original action, the first original action. Mooted means makes it irrelevant, that it doesn't need to be argued anymore because it's been resolved. The issue has been resolved one way or another. And when she went ahead and basically did a majority of what they were asking for with respect to the original action petition for the writ, that essentially is going to take all of those issues off the table for the Indiana Supreme Court because she's gone ahead and done it. So fast forward to this morning, and the first thing that Kara sends me, and I tried to get Kara on. I didn't give her any notice. I sent her an invite. She might be sleeping. She's got kids. And I'm talking about Karen Weineke. And she's the one who drafted, helped on the first one and then was really the author of the second original action petition. So today we get another amicus brief or amicus brief, depending on where you are and how you say it. Basically, this one's from the media, and it's mildly interesting. I'm not going to read through this thing either. You got a ton of media that jumped in on this, and essentially what they're saying that they're urging the Supreme Court to grant the petition because the status quo threatens key democratic values and trust in the criminal justice system, which is true. I'm saying it all the time. Transparency and accountability is why we have these records public. I mean, I could spend all day on YouTube jumping from channel to channel that are all dealing with Delphi, and 90% of them are all dealing with things that are speculative, that are theory, and that are based on the fact that this case has been tried in the dark. You know, I mean, when you try a case in the dark, you're going to get the folks out there that come up with conspiracy theories for everything. Not just the leak, but everything. Everything's a conspiracy theory because an idle mind is the devil's playground. When we're left to start thinking of shit on our own, we come up with all kinds of shit. All of us do. It's human nature. Instead of them giving us the information, we're left to our own devices. And when we're left to our own devices, you get people coming up with all kinds of stuff. Some of it might be true. I don't know. I honestly don't know. You know, you would not believe how many people are in my DMs asking me to review their channel or whatever live they put on. And, you know, look, like I got this thing figured out, or I got that thing figured out. And, you know, I don't have time to really look through it. I typically ask them to give me a nutshell of what they're saying. But, you know, whatever the case may be, I've said it on every live, and I'm going to say it again. The only thing that I care about in this case is justice for Abby and Libby. And in order for that to happen, two things have to go down. One, they have to make sure that they got the right person that committed the crimes, or persons. And two, those persons or person have to get a fair trial. That's it. This is that simple. Like if you can find anywhere at any point online where I've been arguing the fact of why I think Richard Allen is an innocent man, because I do, like in terms of me being biased, I will flat out say it again. And I hope for those of you that disagree with me that you don't just jump off, because I am always open to discussion with respect to how I feel about this case. I've got very close friends that are on the exact opposite side of the fence as I am with respect to almost everything having to do with this case. People that I really respect, people that I know that are extremely bright. You know, we just look at it differently. Now, I will always look at everything through the eyes of a defense attorney because I've done it for 20 plus years. That is my filter. That is how I view things. I am always going to look at it, but I do look at it objectively. While I believe that as it stands right now, and no one's changing my mind, I've had everybody come at me. I've read the same things that y'all have read. Okay, with respect to the evidence that they have against Rick Allen. And where I am sitting right now, it's not even close to being enough evidence to prove beyond a reasonable doubt that he committed these crimes. It's not even close. I'm sorry. Like, no one's changing my mind. If you believe that it is, that is your prerogative. We just have a difference of opinion on it, and that's okay. Like, I'm not trying to twist anybody's arm to come over to my side of it. However, if this thing goes to trial and they don't have more evidence, which I'm extremely concerned, that's the other part of this. I don't think there is a war chest of evidence that Nick McClelland is sitting on. I just don't. I think that basically what we've seen is what we've seen, and that's what it's going to be. And if that's the case, and it turns out that Rick Allen gets acquitted and he's guilty, that's going to be a nightmare. If it turns out that I'm wrong and they've collected a ton of more evidence on him and he gets convicted, then I am thrilled, because it appears that they got the right guy and they had the evidence to prove it. That's where I'm at with this. This isn't fan clubbing. This isn't anything other than the fact that, based on the objective viewing of the evidence in this case, where it stands, what we know, not what we're speculating, not what is theorized, but what we know based on their probable cause affidavit and based on the fact of whether you hate it or not, what is contained in the memo, when you strip away all the Odinism stuff, is the fact that there is exculpatory evidence contained within the discovery that requires additional investigation. It's that simple. Forget about the Odinism stuff. I reject anybody telling me I don't believe the Elvis Field things, because of why? I haven't given, and no one has given me a proper response, because he's got the intelligence level of a 7th, 8th grader. I don't care. The guy said that he was there. He talked about putting antlers. He said he left DNA by spitting on the ground. That requires, in my world, additional investigation. I'm sorry. I want the right people to go down on this thing. And when you've got people out there that 3 other cops saw fit enough to continue to investigate, it has to be looked at. It just cannot be rejected. And people that just want to cast shade on the defense counsel for doing their jobs, because I guarantee you, if you were sitting in their shoes or in their seats and you had that exact same discovery and you're going through it, you'd be doing the exact same thing. You can't ignore that. I don't understand how anyone on the planet is saying that they would ignore that if they're going through the evidence in a case and it's your job to defend the guy, to strip away the fact that they also believe that he's completely innocent of the crime. But just doing your job, we have to investigate as criminal defense attorneys. This isn't just going through the motions. We have a duty, an absolute duty, to zealously represent our clients. We have to swear to it. When we get barred, we stand in front of a judge. In Illinois, it's in front of a Supreme Court of Illinois judge, and they swear you in, and you're admitted to be it, an attorney. And at that point, I'm swearing that I'm going to zealously represent my clients. That word is used. That's not just something I'm throwing out there. It's actually our oath. So when people are saying that, look, the Odinism stuff's bullshit, it's crazy, I don't know if it is or it isn't. But what I do know about the fact that there seems to be exculpatory evidence, and then when you pull out the little pearls that were buried in there, about the fact that paragraph 6, I think it is, says that they found nothing on Richard Allen's electronic devices, nothing connecting him to the girls at all, which then makes it he was just randomly walking on the bridge and decided to murder the first 2 girls he saw. It has to be that if he didn't draw them there, or if somebody didn't draw them there for him. But where's the link to that person? They didn't find anything on his electronic devices. It's right there in the memo. If you haven't read it, go read it for yourself. Don't trust me. Go check it out for yourself. Those types of things bring me to the point where I am extremely concerned about the strength of the state's case, period. And that's where I'm at. And that's where I've been at. I've been at that point since prior to the memo. When the memo came out, all it did was bolster my deep, deep concern about the strength of the state's case against Richard Allen. And what it did after the memo came out is it made me realize that 2 lawyers that have never had any kind of suspensions, nothing in their past, have ever had any kind of discipline of any kind, that are incredibly reputable, that people start casting shade on them. I reject it. And for those of you that are big on the leak thing and that Baldwin was just grossly negligent, which I can't even go there with you, because unless you've practiced law, unless you've tried a case like this, and I'm just going to let you all know it's coming up, and I'm excited about it. I had David Hennessy on my pod today. I interviewed him. That I'm hoping that episode's going to drop on Saturday or Friday or Saturday, one of the two. We first did for our Avery fans. We finally got one in the can last night. It's in Darren's hands. Avery 8 is going to be dropping imminently, and Avery 9 is going to be right after that. So then we're going to have, of course, the David Hennessy interview. If you don't know who David Hennessy is, he is the legendary 40-year-old or 40-plus year practicing attorney from Indianapolis who threw his hat in the ring and offered to help Andy Baldwin litigate the issue with respect to them getting removed. So, and I wanted to have him on because he had been on a subject of the murder sheet, and Kevin and Anya were tough on him, and we had, and I'm not going to be tough on them. I mean, that they were sitting there. That was their impression of what went on in that courtroom. I happened to be the person that Hennessy was speaking to, and I had a very different impression, and it was a very civilized. I wanted David Hennessy to have his opportunity to be able to give his side of it, because when somebody's done that job for that long, that well, and the guy's won 100 murder cases, and I'm not saying tried 100 murder cases, won 100 murder cases. I just want you like that to run around in your mind. This guy's like a legendary criminal defense attorney. And when somebody's going to besmirch him, I'm going to give him this platform, my platform, to be able to say his piece as to what his side of the situation is. And it's that simple. This is no war. I felt an obligation as a fellow member of the defense bar to give him a place to come and speak his mind. And that's what he did. And of course, he was incredibly reserved, and like I knew he would be. And, the guy's just a pro. And so look forward to that. It's very interesting. We touch on way more than just the court appearance on October 31st. We get into a lot of stuff, and he's a fascinating guy. So
I missed a lot, and I'm over here like
you did. I've been trying to tread water.
Yeah, sure. Tread water.
No, I have. I've been yammering on about my typical
Well,
shit.
But I keep seeing myself still freeze. So I'm like over here, like, but did you see this like really amazing? I don't know how to make. Oh, did I just do that? Wow.
Did I see what?
Dawn. Oh, I put it up there. Dawn gave $50 and asked this question.
Oh, but we're going to do the questions at the end. Remember, we turn these into podcast episodes. So, and again,
I was so excited by that.
I'm going to say this right now so my producer can pull it out. Okay. Because we turn these into podcast episodes. Remember, first and foremost, I am a podcaster. I am not a YouTuber. I have a YouTube channel now, but my pride and joy is the Defense Diaries podcast. If you have not listened to it, I highly recommend it. Start with season 1. My father was John Wayne Gacy's attorney. He gave me all his taped interviews with Gacy, preparing him for trial. It's not a Gacy fanboy piece. It's an incredible podcast that's 36 episodes, and it's as deep a dive there is in any podcast in any genre, frankly, and I'll die on that hill. So check that out. Our second season is a case that Allison and I tried. And then we've got the docket where we handle all this stuff. So these are docket episodes. So just know, folks, our starred people and the people that are generously giving to us, we are definitely going to get to your questions. We are definitely going to get to your shout outs in order to make it easier for my producer to be able to cut the clips, because the show doesn't sound great when I'm answering questions in the middle of what we're discussing. So just know that.
In any event, since we've already sort of interrupted your flow, we might as well read Dawn's question.
Okay, I agree. All right, go ahead, babe.
What happens when an innocent person, innocent until proven guilty, shows the evidence? Our system is broken. Our forefathers are rolling in their graves. Well, I mean, I couldn't agree with you more. And unfortunately, our criminal system is designed that the only way you show the evidence is at trial. I mean, I've got clients who ask that all the time. Well, what can I do? And how can I win this? And I explain, well, there's only one way to win, and that's a trial.
100%.
I mean, yes, sometimes there's ways to get cases thrown out, by suppressing evidence, and then they don't have anything left. Obviously, that kind of thing happens, but they're few and far.
I cannot impress upon people the abject terror that you feel as a defense attorney if you realize, like, in the middle of your case, when you start getting the discovery that everything that your client's been telling you about being innocent is true. Like, I cannot describe it to you because you've never been in that position unless you're a physician and a surgeon who's got somebody opened up on a table and you lose that person and you have that weight on you where you feel as if, man, I did everything I can, or I did everything I could and I still lost him. You still feel that. It's the same thing with an attorney, except it's in my estimation worse because it's all on us. With medicine, you've got whatever is wrong with the patient. If it's cancer and you're trying to remove it and you just can't get to it because it's spread too far, that's not on you as a doctor. You've done everything in your power to try to save that patient. When we find out, and my dad always said it, the worst client ever to have is the innocent person, because it puts everything on the weight of the shoulders of the attorney handling it, because we're the only ones who can stop it. No one else, not the judge, not the prosecutors, not the cops, not the defendant, us. It's more pressure than you could possibly imagine. So that's why I keep saying, when you see these two guys, these former attorneys of his, Rosie and Baldwin, doing the kind of stuff that they're doing, like filing what people consider to be a crazy 136-page memo, you could take one thing to the bank, is that they know in their heart of hearts that this guy's innocent because they've seen the evidence. Now, whether it's a combination of what's in the discovery or if there's more.
And what's not in the discovery.
And what's not in the discovery, and what's
and that
lacking in evidence. So,
right.
It's just like, it's a lot. It's huge. It's huge pressure. It's like impossible to know unless you've done it. It's easy to sit on the sidelines and say somebody's guilty and somebody's innocent. It's a whole different thing when you're in the trenches. It just is. And
so that being said, Don Burke, you can see
passionate about it. That's the reason.
Right. That's what I was going to say. You can see that Bob agrees with you passionately on that on that question you raised, and you're very, very generous. Thank you very much. That's and again, since we're already interrupted the flow, Catherine Graves has a question. Can we discuss your opinions, Bob and Allie, as to if and how the exhibits to the Frank motion will ever become publicly available? Will it make a difference if Rossi and Baldwin aren't reinstated? So I guess the answer to that is, and I'm sure Bob's probably already touched on this, that the judge has said in her most recent order. Yes, babe?
Yes. Well, she's said what?
You can't read my mind. Sorry. Right. So that the judge said that she is leaving that off the docket until new counsel decides whether they are going to adopt it. So if new counsel doesn't adopt it, and obviously that is an extremely clear signal. I mean, these attorneys know this judge does not like this motion. She doesn't want this motion. So who knows if they adopt it? If they don't, it very well may stay off until after the case. I mean, eventually there's no reason to seal it. Once his trial is over, possibly the appeal, but usually it's when the trial is over. Anything that they were keeping out of the public would then be available to the public. And I'm certain there's going to be people seeking to get that unsealed at some point in time if it remains sealed. But we might not see it this entire trial if these lawyers don't adopt it.
I'm going to just say this flat out. If Baldwin and Rosie don't get reappointed to the case, and these two new guys don't adopt it because the judge doesn't like it, there's going to be a serious problem. Attorneys do not base their theory of defense on what a judge might like or might not like, ever. The judge has nothing to do with that. The judge in a case where they are not the trier of fact, meaning it's not a bench trial, meaning you're not using a jury, but you're going to have the judge decide. All they do is act as a gatekeeper for the evidence. That is their role, to maintain decorum in the courtroom and to make sure that the rules of evidence are followed and to gatekeep what evidence is getting in and out. They do not decide what defense theory can or can't be used. Their opinion on that should never be known. They are supposed to be an objective person up there, period. They don't get to sound off, I hate your defense.
Well, they don't get to say they hate the defense, but there are certain defenses that you can't raise to the jury unless the judge finds you've met like a threshold. So sometimes that is different, right? I was just explaining it so that the viewers / listeners don't, think that they can. But that's not what Bob's speaking to.
No, that is not what I'm talking. Like, I'm not going to give like a full civics lesson here in terms of like yes, there are defenses where you have to meet a certain standard in order to bring it, but this isn't one of those defenses. I mean, in terms of alternate suspects, they're going to have to meet a threshold. There's going to have to be an offer of proof. But in terms of saying, this is what our defense is, I mean,
we're presenting it as a Frank's motion, like they did. They don't need anything for that.
Exactly. Well, I mean, they need to make the preliminary finding that they're
right, but they can still, present it to the judge without whether she'll listen to it because there's no preliminary finding. So yeah, I mean, same kind of thing.
I mean, like you said all along, I mean, as far as the Franks hearing, like when you said it to me 2 months ago, like they should have filed a motion to dismiss, because like all of the stuff that they had in that Frank's motion was it was well placed in a motion to dismiss.
Or for bond, we were talking about too.
I mean, that was just going to be like what I expected when they filed the motion initially to let bond, like way back in the beginning. And that was basically where they were saying, look, we've read this PCA. This PCA is thin. And at that point, now we know they didn't even have the discovery.
No.
Like, I mean, they were saying your case sucks right now, and we don't think it's enough. And we're going to make a record of it. We're asking that you set a bond for him because we don't think that evidence that they have in that PCA is enough to keep him in without setting a bond.
Right.
So
all of that would have been relevant. Yeah.
Well, like, because at that point in time, I was having the arguments with everybody out there that was of the mindset that, somebody had planted in their head that they don't like that. If at the time of arrest that they have strong evidence that they they put it in their sleeve and they hold it back. And I kept trying to explain to people, that's not how it works. They're going to put their best foot forward. Does that mean that they're putting everything in? Of course not. They're not putting in irrelevant evidence. They're not putting in exculpatory evidence in their arrest warrant, but they are going to put in their strongest evidence because that is their theory of the case that gets let out to the public, which all of you people out there that believe that he's guilty are basing your entire opinion on. Can't be anything else because there doesn't exist anything else. Can only be on the fact that they arrested this guy and you've read the PCA. It's the only two things that you can say that you think he's guilty on. It can't be anything else because I know for a fact you don't know anything else because I don't know anything else. Right. Can't be anything else. So, so when they bring those things out, those PCAs out, they want them strong because that's what sits and floats out in the public for the 2-3 years it takes for these things to get to trial. And typically it goes unchecked. Typically in a case, you don't get the defense where they're lobbing bombs out there and saying, oh yeah, we read your theory. Here's our theory. And then they lob it out there, which is what we have in this case.
Right. And typically we, the defense, want to hold all of our cards as close to the vest until, until we have to.
Unless we got a slam dunker, like unless we know our guy's innocent, and then you know what I mean? I mean, it depends on the situation.
Right. Right.
And then,
right.
I guess what I'm saying is if they have a situation wherein they believe that further investigation needs to be taking place while trial is pending, instead, because what's going to happen if he gets convicted, they're not investigating jack shit ever. So in terms of this, where they've got 5 named individuals with varying degrees of connection to the girls and connection to Norse paganism and connection to each other, and in their estimation, they think that an investigation needs to be going on now. And I do not disagree with them, because once Alan is convicted, if he is, it's over. There is no more investigating. So I know exactly why they brought this up.
Conviction counsel, except by post-conviction defense counsel, but not by the.
Is that what you want to hang your hat on? Or me?
No.
Or me? Like, I'll go out and I'll investigate some shit. Like, I'm doing it on 2 cases that are not Rick Allen's, but I'll do it for Rick Allen. I'll tell you that now.
And as far as little gamblers, comment here, I mean, you're right. It's going to be extremely hard after all of this. Where you're going to find a jury? It's going to be extremely hard to find a jury, but they do it all the time in these kind of cases, and the judge sort of asks questions like, well, in the face of all of that, can you still follow the law? And when I tell you to be even-handed, be even-handed. And can you ignore that and, honor his right to be deemed innocent until proven guilty? And the person says, yes, they check them off. Okay, there you go. You're in. So it should be harder than it is sometimes. And also sometimes, unfortunately, I have jurors who play stupid to stay on the case. I'd almost guess if they find people saying they've never heard about it, that person sure as shit just wants to be a juror, and you have to figure out which side of the thing they're on somehow.
Oh yeah, I mean, believe me, cases like high-profile cases, there are absolutely people out there that actively are trying to get onto the jury. So, and the problem is at this point with everything that's going on. I mean, I don't know if you remember, Allie, that they're importing the jury from Gull's County, Allen County, they're coming from her county. And obviously it's getting way more news in Allen County than it would have been otherwise. Like that's a huge problem. Like if none of this was going on, then, it's not making the news every day in Allen County, because it's a county that's 100 miles away. You know what I'm saying? So it changes the dynamic. I think that there's going to have to be another motion, whether Gull stays on or not, whether Rosie and Baldwin get back on the case. There's got to be another motion for another change of veneer or venue, one of the two, because I think at this point that jury is going to be tainted as well, because like I'm saying, typically Allen County, they got their own shit going on. They got their own massive crime scene up there, and they don't need to be worrying about what's going down in Carroll County. But when one of their judges is engaged in the middle of a huge firefight, in the middle of a huge case, it becomes news that's getting reported constantly, not just on online and on the paper, but on TV every day. I mean, it's like, and like we've been going on a month and a half here. Oh, Mallory.
So
I'm going to throw Mallory up. Thank you, sir. $10 holla from Mallory. Bob and Allie, no question. I just want to say I love y'all, and I hope that you're taking time for yourselves and resting.
Oh, I'm sorry. I moved it before you.
In the midst of all the chaos, we love the content, but we love you more. Mallory, we love you too.
Mallory.
Thank you so much for the kind thoughts. And we are happily leaving for the Dominican on Monday
so a week of no us. But I want you to answer Pat May's question while we're talking about the lawyers and stuff, and then we can switch back to wherever you were at on the judges thing, because you are aware that counsel has spoken out against Richard Allen or about the evidence.
Yeah, well, I mean, like as soon as they announced the appointments, when I found out it was Scremin, I found out he's he's a legal analyst for a local TV station in Allen County up there. I forget what it is. I posted on my Twitter, Pat May, like follow my Twitter at defense_diaries. And I posted the interview. And yeah, I mean, he comments on the case and he comments on the strength of the evidence, because the interviewer asks him, okay, well, you know, you've read the PCA. It was right when they dropped the PCA, which, if you'll remember, happened months after he was arrested. And, you know, Scremin, just, you know, he's on there as a legal analyst. I'm not spiting the guy. Like,
yeah, but I find it odd that he would have a lawyer who has spoken to the fact that the evidence against him is strong. I think that's very strange. Well, I don't fault him for doing it, but now he's his lawyer. And don't you think it's the consciousness of guilt that he deleted it from his Facebook account? Tell the people how that happened.
Yeah, I mean, as soon as I found out, it wasn't his Facebook account, it was worse. It was his website. Because he had the interview on his website. So the first thing I went to was his website. But then I was able to go to the TV station and find the interview in their archive. So I was able to watch it. And of course I screen grabbed it. So I had it in perpetuity. But I mean, the question becomes, was Judge Gull aware of it when she appointed him? Was she aware of the fact that he had done this, where he had commented on the strength of the evidence? Well, then I can't necessarily sweat her. You know what I mean?
Right, but it's still a shitty position that Richard Allen's in now. And what if other people saw it and, you know?
Dude, well, yeah, obviously, but like, I mean, I'm talking about the appointment itself. Obviously, I don't think either of these guys should be his attorney. We know who he wants as his attorney. I mean, that's what the whole fight's about. I have no question who Richard Allen wants as his lawyers, and it's not Scremin and Libredo. Like, unequivocally, those aren't the guys. They're forcing these two lawyers on him, and they're not the guys that he wants. The guys that were fighting like banshees. That's who he wants defending him. Those two guys, because he doesn't give a shit if the people in the public like him or not. Because, again, I've said it a million times. This is what it looks like when two lawyers believe that their client is innocent. When a lawyer in a pretrial motion files a 136-page motion, they believe their guy is innocent, and they're doing everything in their power to make sure that he doesn't get convicted. And it's that simple. Like, this isn't rocket science. Like,
so where were you at on the judges thing? Because I don't know what you talked about, or if you need to talk about more, or where you want to go.
Yeah, no, as I said, I was trying to tread water waiting for you because you were gone for 20 minutes. So I was just rambling, you know, on my soapbox, pounding my fists and doing all the shit that I do all the time. So what I was doing is I was going through the amicus by the media. The bottom line is, you know, they're obviously in support of the fact. And again, this is related not to the second petition, the second original action. This is related to the, you know, the docket. And so obviously they're saying, look, I liked this quote that I highlighted. I thought it was good. So they basically quote, if I can get to the thing, they essentially, dude, what is going on with this thing? Oh, I got to put the document up. All right, hold on.
I was going to ask.
Yeah, I forgot I took it down. Okay, stop sharing. Okay, so I'm gonna share again. All right, so I'm gonna throw it. Oh, we're little. Does it matter that we're that little? Okay.
I think so. No, I'm just kidding. It's fine.
I think this one's better. Let me see. All right. So I'm gonna throw this guy up one more time. And all right, so essentially the argument from them is that for some reason it keeps like jumping from like where. Okay. So like, I like this quote. Okay. And it's a Supreme Court quote from the United States Supreme Court. And it's one of their primary arguments is that granting the petition would serve the significant public interest in this case, and denying it would have adverse effects. Now, I was going on the rant earlier about, you know, why it's important for there to be transparency with this case, you know, and I was talking about, all the different YouTube channels and all the conspiracy theories going on out there, and all of it. So I like this quote from Nebraska Press Association versus Stewart, stating that the secrecy of the judicial action can only breed ignorance and distrust of courts and suspicion concerning the competence and impartiality of judges, and free and robust reporting, criticism, and debate can subject the criminal justice system to the cleansing efforts of exposure and public accountability. It's a beautiful quote, and it's accurate. It's true.
It speaks to what, that was part of what the original petition's argument was, that the effect on the public is so severe that they're paying attention, and now they're going to have distrust. And I guess it still circles back to the fact that the Judge Gull is arguing that that's not the kind of harm, and it's not a significant enough harm to warrant the kind of extreme remedy that this type of writ seeks.
Definitely. 100%. And so that's basically the amicus. And so at this point, in Allie, I read through the order when you fell off, in terms of when she was like, and I explained that the purpose of her doing that was to moot out a majority of this particular first original action, which she did. She really did. She mooted out a lot of it. And she threw the clerk under the bus. You
explained to them already, I'm assuming, how she mooted it and what she did.
Yeah, well, I read the order. So when she stuck all the things that they asked for in the original action, that's how she mooted it. She basically didn't wait for the court to do it. She fronted it and said, okay, I'm going to do what they're asking for.
You to do.
Exactly. All right. So today it was due.
There are let me just let people know there are no bombshells of information that have been released as a part of this. There's no transcript. There's basically nothing but her argument. And the fact that, as Bob just said, her power move was telling the clerk to, put all of that stuff back on the docket so that she could also argue as a backup argument that everything they wanted done is basically done. And now there's really no reason for this court to have an opinion at all.
Right. Exactly. So instead of, and I'm not going to read this whole thing. I know that, like criminality, I know Teresa read it, and I think probably others have read it. And I think that we probably have a bunch of people in here, so I don't necessarily need to read it. And frankly, it's not that interesting. What we'll do is we'll just kind of go through the arguments, okay, in terms of what they are. And then I highlighted a few things in there, and we'll go through it like that. So her arguments are, one, that the relator does not meet the condition precedent. Oh, you know what? I'm sorry. Let me pull these banners off. I've had people say the branding gets irritating when we're trying to look at stuff. And I agree. It gets in the way. Okay. So the relator does not meet the conditions precedent or mandatory requirements to seek a writ. So that's the first. And typically they're going to put their strongest argument first, because, as my wife will tell you, a woman who writes incredibly long motions, I'm always like, babe, the judge is never going to get to page 46 of it. You got to put, so, and that just stands to reason. You always hope that a judge will read thoroughly, incredibly long pleadings, but you have to assume that they won't. So it's smart that you're going to put your strongest arguments first. And I think that they did. I think that her attorney did a fine job with it. In terms of the response, it's absolutely the proper response. So the relator does not meet the conditions precedent or mandatory requirements to seek a writ. So the relator admits that he failed to comply with the conditions precedent for original actions to seek relief from the trial court, which is true. So they did admit that in their pleading.
Right. And just to explain it better, there was a good part that I could read. Well, I was going to read not from there, so you could keep.
No, yeah, just read out loud. It's fine.
So they indicate that, the relator admitted that they didn't file anything in the lower court. And that's one of the rules, that before you can come to get a writ, you have to you have to, when they say comply with the rule, they're saying file a written motion in the lower court. Now, that's not dissimilar to the way appeals work. You can't go appealing something that you didn't present to the lower court. So, and they did address the fact that they didn't, they being the defense or the relator, addressed in their motion that they didn't take this step and argued that it was because the judge was offhandedly just not hearing anything. She wasn't entertaining anything. She wasn't even putting it on the docket, and that his only lawyers that could have done it were gone, basically saying that these new lawyers would have had no kind of basis to do it. So they do point out that the lawyers who filed this original action, they could have filed a limited appearance in the lower court and filed a written motion to demand these things get put back on the docket, to unseal things, to do a lot of the things that they asked. So that's their first, argument. And it is, a relatively strong argument because the Supreme Court, it's form over substance a lot of times. So that first argument is, a decent argument that it wasn't impossible, that they should have tried. And then they go on to say that too much time has passed. Too much time has passed because so many, it's been so long since put up the 4 items that they're asking.
So like in the intro or
it's actually in the body. If you keep going, you'll see it with the dates.
So do you want me to go where they're talking about how it wasn't expeditious?
Yes.
Okay. So here it is.
So keep going until they show the things that they asked for. Well, there you go.
Oh, so the 4 filings. Okay.
The dates. Yeah. So they're pointing out that there's case law, established law in a case where they waited 40 days, was it? Or 44? Yeah. 40 days before filing a writ, and that under the rules, as it says here, application has to be made expeditiously. So the judge is arguing that he could have done it in June. He could have done it in July. He could have done it in September. He waited too long. I suspect that a possible response to that argument could be that this was a continuing issue based on the most recent one in October, that this was a judge who was doing this over and over again. So it should be considered like a continuation from the first and allow them to get around this timeliness, expeditiousness argument.
And just so y'all know out there, and when you have a response like this, what's done in both appellate work and in this case, a response to a writ, is they're citing case law. You have to cite case law. Precedent is what rules the day. So to go to exactly what Allison was talking about, they cited 2 cases. One of them happens to be an Indiana Supreme Court case. And of course, and when you're reading language in a document like this, they call it the holding of the case. It's the rule of the case. So for example, this court has found that a delay of 42 days was too long to seek a writ with this court. And they cite the 19th hole, and then they give the 189 Northeast 2nd at 425. So that's a citation. It's a Scoyne case, and it seems pretty clear cut. It seems pretty unambiguous. 42 days they found was too long. So then when you go down and you look, obviously it's been way longer than 42 with respect to the June 20th, the 28th, and the July 5th, and the September 18th, all of them. So
there's one more below that.
Oh, and the October 25th, that's the only one that would fall under it, and those are the ones that she has declared that she doesn't have to listen to because, at this point, they're not the lawyers. So she says, look, stick them back on the docket, but I'm not going to throw them up there or I'm not going to rule on them because they're not the lawyers anymore. So I agree with Allison. I think in terms of just kind of like nuts and bolts arguments in terms of the rules, it's a strong argument. They started with a strong argument.
And just to, if people remember, if many of you were here when we had the lawyer who drafted the writ on, I mean, she said she had no expectation that this, writ was going to actually get granted. She said they almost never take any action on these things. So,
and she knew, and they knew going in what that issue is. That's why they were saying in the first argument that the relator did admit that they knew that they didn't comply with the requirements, and then they tried to cram it in, come in through the back door by talking about it was extraordinary circumstances. And so you got the second one there, which Allison just went.
And just to mention, the judge puts it's in a footnote. She recognizes that October 1 is expeditious and says, but I'm responding to that issue in the other action, because it actually deals with the judge denying him his right to counsel. Right.
Exactly. All right, Allie, go through C here. Can you read it, or is it too small?
I've got it up on my phone as well. So we kind of touched on this earlier. The argument is that it will not, that they have not established in their petition and their brief that it's going to cause the type of extreme hardship that this court considers, and indicates that as far as the relator, the relator being Richard Allen, there is no hardship argued to Richard Allen, again, with the exception of, the last one that she's addressing in the next petition. So this is just kind of law that speaks to the type of things that to establish this is not the type of hardship. The type of hardship raised to the public, and that's the same thing Bob mentioned to you guys when he was reading about how are you saying amicus now?
Amicus. I mean, it's either amicus or amicus.
Right. I think amicus is probably more accurate, but so used to amicus. So, that they pointed out how this is going to create such distrust in the system and bring issues from the public. And Judge Gull's arguing that's not the kind of extreme hardship that this very, special type of remedy is used for. And then she goes on from here to point out, and it sort of goes, hand in hand.
Yeah, and as you can see, that 19th hole, which they cite again, it's typically what they refer to a case it's on point. So like that saying that everyone uses a lot, they were on point. Actually, lawyers have been using that phrase for forever, because if precedent is kind of right on the button in terms of the issues, they consider it to be on point. And like these arguments are right on the button with what was going on in this case. And to me, and I wanted to ask you, Allie, what's interesting, because look, in a case where we will file what they call a motion to reconsider in trial court all the time. Like if we do a motion to suppress and the judge rules against us, we have the opportunity to file a motion to reconsider, or we'll cite case law, and we'll argue, well, we think Your Honor missed on this one, and we're asking you to basically go back and rule against yourself, which, as you can imagine, rarely happens. And it's essentially the same thing that they want them to do in this situation, where they know how she's ruled on certain things already. They know that she's found certain documents to be, confidential and not accessible to the public. And so, their expectation and the rule is that they've got to bring that action into the lower court, have her deny it. And at that point, once she denies it, they can either then file a motion to reconsider, which she would deny again, and then go up. But they skipped that step. And, they argued that because of the fact that they're ready to go to trial in 2 months, that, and they're stuck on that. And you weren't a part of David Hennessy's conversation, but we got into that. I asked him flat out, because there's a whole camp out there that thinks that was just a bluff, that, there's no way that Rosie and Baldwin meant that they were actually going to be ready. And he assured me that they were 100% ready to go. They would have been ready to go in January. That's going to be one that everybody's going to want to watch if you're interested in the case, or listen to on the pod, because I recorded it. I'm going to eventually put it on as a video on YouTube, but I'm putting it on as a podcast episode first, because you should all be listening to the podcast anyway. We get into things more thoroughly, and we're not interrupting each other nearly as much as we do here on YouTube. But it's a very interesting, thought-provoking conversation that I had with Hennessy. So
the judge, she follows this argument up with a very comparable argument. She talks about, as you're putting up there, that the relator fails to show that the remedies available by appeal will be wholly inadequate. And why I say those two are tied together is because that argument just before was basically, this is not the type of hardship that this kind of extreme remedy was built for. And she's backing that up by saying that they typically handle these type of issues on an appeal. And they go through various cases where people, like the press comes in and, basically motions to be part of the action, and then asks the court to unseal something or do something like that. And then if the court denies it, I guess they're, because most of the cases they used are civil cases. And in civil cases, you can always take what we've explained before as an interlocutory appeal. It's before the end. It's in the middle. But they did cite one criminal case. So maybe they do allow interlocutory appeals by, like an interpleading party, like a third party stepping in to try and get the court to do something and take it up on appeal. So this whole argument is that there is a remedy available by appeal, which is another prerequisite to being able to bring a writ. You have to show that there is no other remedy available under the law. This is the only way that I have to get this issue addressed. Please, 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 Supreme Court, listen to me and address it. So it's another, decent argument.
Yeah, I mean, in terms of the arguments, it's a strong response. Now, yeah. I know that this attorney that handled this is not the same attorney that is handling the second original action, but I anticipate that will be equally strong in terms of the pushback. One thing that people need to understand is that Judge Gull is not going to be laying there allowing herself to be a punching bag. They will respond, and they will respond with case law, and they will respond with cogent arguments. And
will they come with receipts, Bob?
I assume that they will come with receipts. And ultimately, it's going to be, I think it will boil down to the simple question of whether or not that move where they entered their pro bono appearance at the very end, taking away that whole question of continuity, because once they entered their appearance and they became his private counsel of choice, it mooted that argument as far as I'm concerned. It then became a completely different argument under the eyes of the law. So
that's why we had been saying all along, like if they just file their appearance, they make their case so much stronger. And then they eventually did. So now
I have no idea if Brad saw the messages that I was sending him, but I kept sending him like, hey man, just enter your pro bono appearance, because Allison was like, he just needs to enter his pro bono appearance. And I'm like, yeah, that's what he's got to do. So I started messaging him. He never messages back, but I was definitely.
So now this is where sorry, I already had someone complain about me interrupting you.
No.
She starts getting to the actual merits and saying to the court, but let's assume that all those conditions that we just talked about that make it that they shouldn't be allowed to even bring this motion, that the court should just throw it out without considering it, don't exist, and they met those. they still lose. But the argument being made here is almost laughable. And, it is just disingenuous because she's blaming the clerk. Well, it's not my fault. This is the clerk's job. The clerk's supposed to do all this stuff. But meanwhile, she still did tell the clerk not to do her job, but technically it is the clerk's job. Maybe the clerk should have been brought in as a,
the clerk is supposed to respond, so much like the judge. And I know that somebody had asked the question, and unfortunately I do not know the answer. And it was Digital had asked, is the AG's office representing the clerk? Is that why they refused to represent Gull? It's a great question. And as far as I know, the answer is no, but don't quote me on it. I have not heard anything about the AG throwing his hat in the ring as to any of these issues at all. So, it does become the question, who does the clerk, I don't know. I haven't seen, if anybody in the chat happens to know if they've seen an appearance filed on behalf of the clerk, I'd love to know it. But it seems like their response would have been due today as well. So they may be standing mute on it, like not responding, so, but you're 100% right. And this is it. Respondent has issued an order directing the clerk to make available to the public on the CCS all non-confidential documents. The related request be made public. So that is relating to the order that we went to when you were offline. In any event, the respondent, meaning the judge, has no absolute duty to maintain the CCS. That is the clerk's responsibility, not the respondent. So that's exactly what Allison was saying. She's putting it all on the clerk. Okay. But if you read the orders, look, the circuit clerk has many clerks that work in there. There's one that's elected, who's the main clerk, whose name that you see, the circuit clerk of whichever county. And then they have a bunch of clerks that are in there, like the nice clerks that send us the documents when we ask for them, and the nice clerks
handle the day-to-day stuff.
Yeah, all the day, like the minutia, like every day that there's court orders that are drafted, and they go in and they do their job and they stick them in there. And when the judge is ordering things in the actual orders, they abide. Like you're not going to have a clerk sitting there saying, when Gull is saying, hey, this is confidential, do not put it on the docket, or I'm telling you to pull the memo off because it should have been redacted and it's confidential. They're just doing what the judge is telling them to do. They're not in a position to say at that juncture, well, no, I'm not going to do it, Your Honor.
I think technically that was part of the argument, was that they are supposed to tell the judge, this is outside of your purview.
They are. But, short of the clerk going to the judge and saying, hey, judge, because it becomes a legal argument at that point, with respect to the clerk, who is the legislative branch. They're not in the judicial branch, and they're going into the judge's chambers and saying, look, this is in violation of the law. Clerks aren't lawyers. It puts them in a very difficult position where you've got a judge that's running her docket, like there is, there's that aspect of it that the judge's docket is the judge's domain, in the sense that they have a responsibility to make sure that things are filed in the case. Like the judges in our counties are always like, look, if it was Zoom court, if you don't have an order into me by 1:00, I'm SOJing the case. I'm getting rid of it. And then you're going to have to file something to get it back on my docket. So, they have rules in place because they're trying to maintain their docket. So, and then she gets into this one, which is, basically the truth, which is most of the relief the relator seeks is moot. And that's basically referring back to that order that I just read on November 14th. And it says that the trial court issued an order that resolves most of the public access issues raised in the petition. So In other words, that makes it moot. And for the one that it doesn't, she's ordered the Carroll County Circuit Clerk to put the 118 documents previously made remotely accessible by the court on the CCS. And that's instanter, instantly. She also ordered the two other things, the sheriff's filing and the letter from the DCO Department of Corrections.
Speaking of which, I'm about to save to you that letter because everybody wants to hear it.
Okay.
So you should be able to find it now. It's not in like the Avery specific, but it's in the defense diaries.
Are you talking about this letter?
Oh, you already have it. Sorry.
Yeah, man. Like I'm trying to prepare for this stuff. I'm not coming in here. Like if I don't have my documents ready, it gets ugly. You know what I mean?
All right. So why don't you read the letter since it's been brought up at this point?
Okay, let's get into it. All right. So this letter was sent by Robert P. Baston. I looked him up. He's in on a high felony. It looked like it was sexual abuse to a child. So, and he's convicted. So let's just remember, Richard Allen is in a prison, and prisons are places that house convicted felons. Okay. Typically pretrial detainees are not kept in prison. They're kept in county jails awaiting trial. It's one of the issues that's been argued repeatedly in this case. So his letter to the court, I, Robert P. Baston, gives his inmate number. An inmate at Westville's restricted housing unit was subpoenaed to appear in the above case number on Thursday, June 15th, 2023, 7:30 a.m. in Carroll County Circuit Clerk. And I was there that day. That was the day that they had the first go around trying to get Allen out of the prison. Okay. He says that due to the corruption and retaliation by Westville's restrictive housing unit staff and officers, I had to refuse to appear in the above mentioned court hearing due to my safety and fear for my life. It's big words. I mean, when you look at something like this, you're immediately thinking, okay, well, what does this guy have to gain? And he's got nothing to gain by writing this letter. I mean, like he's
definitely not helpful because it puts him at risk. And even if he wasn't getting harassed before, he's sure as shit getting harassed now.
For certain. And like they're not chopping, like no one's chopping time. No one's doing him any favor from the state side saying, hey, man, we really appreciate that letter you wrote. And we're going to chop a couple of years off your sentence, dude. That's not happening. Like he has nothing to gain from this letter, So as shitty as a human, it sounds like he is, assuming that he is convicted properly. I mean, this has weight because he's got nothing to gain. So I was housed in a cell just above Richard Allen's cell. And they give Allen's cell number due to being a voice on how Richard Allen was being abused and mistreated by corrupt sergeants and officers and administrative staff and mental health professionals in Westville's restrictive housing unit. I was retaliated against and moved by orders of Warden John Gallipo. I'm not sure if I'm mispronouncing that or not. Captain Gary Lewis and restricting housing unit manager Mrs. Tracy Cornett. I was moved to the restricting housing unit B pod after reporting Sergeant Brandon Williams and his officers trafficking contraband to inmates in A pod to the Indiana Department of Corrections Office of the Investigation and Intelligence Internal Affairs in a recorded interview on April 28th, 2023. 5 days after the interview on Wednesday, May 3rd, 2023 at approximately 7 a.m., Sergeant Brandon Williams and his officer, while I was in full restraints and leg shackles in Westville's restrictive housing unit, receiving area on security cameras will show Sergeant Brandon Williams ordering an officer to put my mattress and urine in a cell that I was placed in the night before without a toilet and running water in the cell. Security cameras will show Sergeant Brandon Williams slamming to the floor, I think he missed the word me, slamming me to the floor and violently breaking my foot and ankle, and then intimidating the nurse not to treat my injuries when Sergeant Brandon Williams had an ink pen in the stab vest that he was wearing. He then stabbed me in the elbow all the way to the bone.
Wow.
It's pretty brutal. I was then placed in a cell 201 in B pod. Then at 10:45 a.m. on the same date, Sergeant Brandon Williams gave, quote, no verbal command to cuff up at my cell. And he dropped the handcuff port in the cell door and sprayed him or OC prepper spray in the cell, and then left me in the cell for 10 minutes, asphyxiating for air. I was then handcuffed and removed from the cell out of view of the security cameras and taken into the hallway where an officer, Quentin Davis, was waiting and told Sergeant Brandon Williams and officers to hold me up, while Officer Quentin Davis violently punched me in the ribs and stomach, while an officer, Mr. Motts, ooh, it's almost me, kneed me in the face, while Warden John Gallipo, mental health doctor Monica, can't read it, Walla, and Mrs. Bourne were watching the beatdown from outside Captain Gary Lewis's office. The nurse again was intimidated not to treat my injuries, and I was placed back into cell 201 B pod. I was placed on strip cell, and my personal property was taken. When I don't know if that's eventually, I don't know what it's supposed to be. Eventually, I think he's supposed to receive my property back. My legal documents were either destroyed or lost or taken due to incriminating records, dates, and times. Some of those record dates and times concern how Richard M. Allen was being abused and mistreated by staff and officers. My personal property was left out in the hallway unsecured in the Westville Restrictive Housing Unit. General population workers and suicide companions were stealing my property. I recently received from the United States Department of Justice investigative report number. The U.S. Department of Justice has been in the news for mishandling complaints. The Indiana Governor's Office of Ombudsman Bureau has also mishandled complaints on the Indiana Department of Corrections and the corruption going on in the IODC or IDOC facilities. The Indiana Department of Correction offices and the Investigation and Intelligence Internal Affairs is allowed to police itself and covers up excessive use of force and assaults on inmates by IDOC staff and officers. I've also been corresponding with the New York Times investigative reporter and her team at the Yale Law School that I have been sending documentation and evidence to, but due to the corruption, my legal mail has not made it to its destination. So until this court can protect me and other inmates at Westville Restrictive Housing Unit and report the excessive use of force, assaults, abuse, mistreatment, torture, and retaliation from corrupt Indiana Department of Correction staff and officers, then I do not feel safe to testify in case number, and that's Allen's court case. When a pattern can be shown of the above mentioned issues by researching the named individuals mentioned in this court letter in the United States District Court, Northern District of Indiana, 7th Circuit, which is our circuit as well, that clearly shows a pattern of excessive use of force, assaults, torture, abuse, mistreatment, and very poor mental health treatment. Again, I have witnessed Richard M. Allen being abused and mistreated by Westville Correction Facility, Westville Restrictive Housing Unit staff and officers that has affected his health and mental health. And then he signs off. So there's that. I mean,
Wow.
You know, I guess take it for what it's worth. Again, this guy's
and the judge sealing this, what BS?
Sealing it in lieu of him showing up. Like, I was there that day. You know, they mentioned this letter at the hearing, but they didn't read it into the record, you know, because he was subpoenaed to come and he declined to come, and he gives this written reason as to why he didn't come. So, I mean, look, everybody that kind of cares about this case and cares about a fair trial and everything else, like I've been concerned about his well-being in there. You know, it's one of those things where when you read stuff like this, is it shocking to the conscience? Yeah, it is. But is it surprising to me? No, it's not. I mean, I've said it on I don't know how many lives that this is reality in prisons around not just Indiana, but in this country. You know, and that's where Richard Allen is being housed prior to being found guilty in a court of law. and there's a problem with it. And, you know, Gull's had 2 opportunities to move him, and on both occasions she's declined. So, I don't know. I don't know. What do you think, Allie?
I mean, I think it speaks for itself.
I think it does too. All right. At that point, I mean, we're caught up. So I want to go through mods.
Wait, what about the
go through the starred stuff.
No, what about the rest of the judge's thing? We're done?
Oh, pretty much. Hold on, I'll jump back to it. Okay. So this is her continuing argument that the clerk, not the respondent, not the judge, is required to maintain the CCS.
And she's citing the law, where before it was sort of an intro.
Right. Respondent has no absolute duty to maintain the CCS. The clerk of Carroll County or Carroll Circuit Clerk or court, not respondent, is responsible for maintaining the CCS.
And that's when she mentions the words absolute duty, because again, that's one of the requirements to bring a writ. You have to show that someone who had an absolute duty isn't, doing that duty. So,
I mean, like, so, and Kara, when she emailed me this morning, was like, man, like, she's contemplating whether or not she's going to respond to this.
She might as well focus all her energy on the other one.
I agree. I mean, at this point, like the judge said, she's pretty much righted the wrongs, but like a counter argument is the clerk supposed to, if she's not creating orders, because she talks about the clerk of the circuit court shall maintain a sequential record of the judicial events in such proceeding. Is she suggesting now that the clerk writes orders up as to what happened?
No, she's saying that the clerk shouldn't listen to her, and they should be the one that makes sure everything's sequential and on the record.
Okay, but what happens if the judge isn't writing an order up, which has been the case on multiple occasions? Court appearances have appeared out of thin air. Like, I mean, what is the clerk supposed to do with that? I mean, there has to be a court order in order for the clerk to enter it. Circuit clerks are not writing court orders. They don't have the authority to write a court order. They don't have the authority to sign a court order. They have to be signed by the judge. So if they're not being written, I mean, that's clearly a counter to that argument. But I agree with you. At this point, Kara should just put all her, energy aside from her regular practice, as she's doing this from the goodness of her heart, and because of concern about the way this case is going, she's going to have to focus on the response, which we're not going to get until the 27th. And that's going to be a day. I mean, that's going to be a heavy duty day. And we're just going to be getting back from the Dominican. So I'll be refreshed and ready to go when that thing comes down. Because that's going to be a good one. Like, that's going to be a good one. I'm going to be so excited to read that. I really am. It's like this is major litigation in the middle of a case. Okay, so then she adds, respondent did not abuse her discretion in managing the docket, much less violate an absolute duty. You want to speak on that at all?
Yeah, I mean, to get to the interesting part when she turns to the Franks motion, because at first she's just saying, like, basically, I didn't do anything wrong anyway. I've got a lot of discretion in how I manage the docket. And it says, it's a couple paragraphs down where she specifically speaks to the Franks motion.
Okay. I'm getting there.
There you go. Ooh. Oh, no, next one down. Sorry.
Okay. Oh, boy, there it is. There's the old Franks motion rearing its ugly head.
So go ahead, read that paragraph to the people.
Okay, so the relator also seeks to unseal or restore public access to the Franks memorandum. The Franks memorandum contains the full first and last names of the deceased minor children who are the crime victims in this case. CEG record, pages 57, 70, and 106. And again, when you see a citation like that, she's citing the record, the court record. So she's citing the memo itself. Names of minor children are required to be redacted from court filings in federal courts. And that is Federal Rule of Civil Procedure 5.2a. Indiana, in turn, excludes, quote, case records declared confidential or excluded from public access pursuant to federal law. and that is Indiana Access to Court Records, Rule 5B1. Therefore, the Franks memorandum is, quote, marked as confidential because counsel failed to supply a redacted version at the time of the filing, end quote. And then sup record, page 5. Respondent has ordered realtors, or oops, he made me do it, relators, new defense counsel to review the pleadings and either adopt them or make their own. If counsel adopts them, quote, they are ordered to file a redacted version. So we know now when she talked about the redacted version, because she had that same language in her order, that what she's saying is they have to redact the girls' names. Okay. So do you want me to read this?
No, that pretty much covers everything. Then the judge just argues that they didn't cite any law in support of some of their arguments and that the court shouldn't consider it.
Okay. So when that part came out and Kara emailed me this morning, she's like, are you kidding me? And then she starts sending me documents that were filed by the state that have the girls' names in them that were not filed confidentially. So, I mean, it's a weak argument. I mean, unfortunately, everybody on the planet that follows this case knows what the girls' names are. I mean, the mere argument that that's why she redacted it seems, out of everything that could be completely construed as disingenuous, that is the most disingenuous thing. You know, I mean, look, if it's a juvenile case, those types of cases are lock and key. Like, you don't know. They do protect the victims' names in those cases. They also protect the perpetrators' names in those cases. You know, I mean, like everybody that's a minor in juvenile court, you know, like they don't allow the public in there. This isn't that. This is, and it's like there's a distinction between, you know, yes, of course, the thing we care most about is justice for Abby and Libby, but this case is about Richard Allen. This is his trial. It's his rights that are being affected. And, you know, we can't forget that part of it, you know, and that part of it is what gets us to the part where we're trying to seek justice for Abby and Libby. So if the Richard Allen part is being screwed up, you know, it's an issue. So, I mean, ultimately, I have no idea what these two new guys are going to do with the.
I wonder if that rule specifically, and I'd have to look at it, applies when you're dealing with a deceased victim, because that there would be no need or reason to redact. They're not really a juvenile anymore; they're deceased.
Right. I mean, with a case like this, I mean, they like in Garcia, they didn't redact Thomas Hunter's name. You know what I mean? He was deceased, you know, and I mean, you have to, like, you've got to name the victims in a case like this. Richard Allen isn't being tried in juvenile court. He's being tried in big boy court.
No, but if it was like an abuse case or something where there's a child is the victim, they do always use their initials or, you know, something, not their names, but
yes,
you know, we've only obviously, you know, I'm trying to think if we were involved in any others where minors were the death victim, but I just don't think that rule would apply when the victim's no longer alive.
Yeah. And I mean, obviously in aggravated sexual assault cases, you know, oftentimes, you know, adult victims, you know, they'll protect their identity as well. You know, so there's definitely circumstances in which, but again, those are all people that are alive because you're trying to protect people's privacy. And
I mean, how can she, I'm sorry, I just interrupted you again, but just irritating to me that she let like all those 116 documents get filed, several of which had the victim's full name. And now she's trying to, you know, argue this. Like, I don't know. She should have maybe read what her lawyers were filing and been like, well, that argument might actually backfire because I've let several other pleadings be of record and accessible despite that.
By the state, where they state both the girls' names. So, all right, let's go through some starred stuff. Jedi Platypus very generously gifted 1 Defense Diaries podcast membership.
Or take the thingy down, babe.
Oh, the document. Okay.
Yeah, and then.
Okay. And then we've got, let's see, Charmaine always coming through, as always, like the champion she is, with 5, the generous 5 Defense Diaries podcast memberships. Dawn Burke, like Dawn did some heavy lifting tonight. That one we went through. Christine, $5 holla. Thank you. Thank you very much for that super sticker. Mallory, thank you again for more than the money. Much more than that is the kind thoughts. Thank you. We do adore you. Lead with love. And they should not be showing their preferences on a public Facebook account. What judge does not private their Facebook?
Yeah, I absolutely agree. I mean, it's definitely something they're supposed to be weary of and conscious of, so that people don't, take their, their preferences and decide that have a certain type of mentality or they're going to rule a certain way. It is not good practice.
I agree. And plus, like, I mean, is a judge, a criminal judge, I'm not trying to be out there in the public when you're sentencing people. You know what I mean? All right. Kit Kat. How do you guys feel about the guy in Westville with Rick who refused to come to court because his safety was being threatened? Is this something a judge would normally conceal? So we addressed
that. You guys, obviously that letter that we just addressed, but no, that is not something a judge would normally conceal.
Right. So
I don't know what she's like worried about the publicity for the jail.
Or the fact that she had every intention on keeping Alan there. You know what I mean? Like, that's probably the more likely reason. Pure Prof wannabe. Since Justices Massa, Moulter, and Rush are up for retention vote in 2024, in your opinion, can the Supreme Court reinstate Baldwin and Rosie and 1026 and 1028 motions and let the special judge decide the motion to recuse and or disqualify at trial at the trial court level? So, i.e. punted. So, I mean, we're going to find out.
When he says let the special judge, he means Judge Gull or a different special judge?
I cannot see a world in which Gull would be able to rule on that day, to hear and rule that motion. Like, this isn't like they're, and I told you about the woman from California who's like, oh, you're misstating the law. You can't, they're in California, judges sit on the, not in a case like this. Like there are situations where a judge will be asked to recuse themselves because of a conflict. This is not that. I
reread his question and now I see where he's going. He's asking it's something that the Supreme Court can bunt it and say, we're not going to decide it, but send it back. That is typically what they would do. They would say, this is going back to the trial court. Somebody is going to entertain this and look at it. And then it get ruled on by a different special judge or something else. But it is unusual, although the court has the discretion and the power to decide to give the ultimate remedy asked for. Like, this is so outrageous and clear cut. We're going to grant it right now and send it back and tell the trial court that they've got to do what we've said. It is the more typical scenario that they said, you didn't do this right. I'm sending it back for you to do it right. But they don't typically make it right themselves.
Yeah. All right. Megan Z, question. Once you opt for public defense, can you not switch to private counsel at any point? Yes, you can. You can always switch to private counsel. You're never stuck with if you can raise the capital. I mean, Alice and I will often, when we consult with a potential client early on in a case, we understand that because the wheels of justice do turn slowly, we'll say, look, just take on the PD for now and gather resources, gather money. And then, a year and a half down the road, when you've got some money put together, hire private counsel. And again, I am never casting shade on public defenders. My father was a public defender for 15 years, and the guy was an unbelievable lawyer. David Hennessy, who I talked to today, public defender for 15 years. The guy's a hell of a lawyer. You can get great lawyers as public defenders. The problem is always, always, always time. They just simply do not have the time to be able to dedicate to a matter like this. And remember, even though Baldwin and Rosie were appointed to this case, they are both in private practice. This is not a case where they work in a public defender's office and they've got just a desk filled with files of clients that are all appointed to them by a judge. They're not full-time public defenders. They were appointed to this case to handle it, and they were going to be paid by the county. So it's a different circumstance. That's how they came up with the time to put into a 136-page memo. And I cannot impress upon people like how much work would go into a motion like that. I've seen it with my own eyes in my own house with my wife sitting at a table for 4 days straight, like 24/7. It's unbelievable.
So this next question is good for you because you actually looked into it. Could we interest you in a crowd funding pro hoc vici? So everyone knows that what this question is saying, can we, Bob and I, be convinced to apply to appear special in Indiana, even though we're not licensed there? And the answer to that, even if we could, I wouldn't want to. But tell them about the crowdfunding.
Yeah, I mean, what we know about crowdfunding is that any of the typical avenues that people use, Kickstarter and the like, they all have a policy that you cannot use their app in order to raise funds for a criminal defendant. So, which
is, I think, BS. Like, that is ridiculous.
I know, it's almost like a presumption of guilt, right?
I don't know what the hell it is, but it's
almost like a
because
presumption.
Bob was like, we got to do a crowdsource. We got to raise money so he can hire. When this was before Rossi and Baldwin went in and had tried to do it pro bono. And he was like, they don't let you do it. So, and thank you, Lead with Love, for that $10. That was very thoughtful.
Sweet dreams, Wave. Say goodnight, Mom. I love you. Or run down and give her a kiss.
I don't know the answer to this question. I think we have an Indiana lawyer in the chat that does.
There's typically a bunch of lawyers in here. All right, go say goodnight to Mom.
Do you know if Indiana is one of the states that allows questions? Have you seen any other trials in Indiana?
Is this the question from Carol? When, if this eventually goes to trial, are jurors in Indiana allowed to ask questions of witnesses through the judge? I don't know, and I'm not going to guess. I don't think so. I know that there's multiple. What a ham! I know that there's multiple states that do allow for it, and I love the practice.
Travis Williamson answered that already. I didn't see his answer. I'm seeing him say that he answered it, but I haven't seen his answer. I'm looking.
Well, retype it, Travis.
Yeah.
So Carol, when Travis gives us yes, they are encouraged. So they can ask questions. Awesome. I did not know that. See, that's why I didn't answer the question, because I did not, but I love that practice. I like, how many times have we sat in a trial or watched a trial where we're like, oh my God, ask this question. It's like, it's got to be the same thing with jurors.
I mean, I think it's great because it gives the lawyers a little window into what they're thinking and what kind of issues they might want to focus on and arguments to make in closing. Wow. Now she's behind you.
Yeah. Go to bed. It's past your bedtime. Go to bed. I love you. All right. Come on. We've got a lot of people on here.
Bye, live.
I love you. All right. So that was a great question, and I didn't know the answer. So, and thank you, Travis, as always. Johnny on the spot. I love having you in here. Chrislyn Kendall, $20 holla. You guys are phenomenal. Thank you. You Kristen are phenomenal. Thank you for sharing your unique perspective and getting the facts out there. Love you both. We love you back. We appreciate you so much. Dawn Burke, remember I was telling you she's doing like heavy lifting? I mean, for real though. So I watched the Take Care of Maya case. I commented on that like a lot, that case, for both Court TV and Law and Crime. And the attorneys fight for right or wrong. I see both sides. We need to fight for justice. I could not.
I mean, that's definitely true. There are lawyers who will fight on either side, but it is unusual in, you know, a criminal case to have your public defender pull out all the stops and like overdo and you know, obviously he's still going to fight for someone whether they're innocent or guilty, but so yeah, I mean, and we also see, you know, the need for both sides. And
Hunter, I mean, you can't have justice without both sides. I mean, like you have to vet the evidence. Like it should never be a one-sided fight, because that's not justice. You can't get justice that way. It's the same thing I'm always talking about. I'm like, no one should be forming a final opinion, including myself. Like I haven't formed a final opinion on Richard Allen. I just happen to lean heavy innocent just based on what I've seen. Like I said, if the thing goes to trial and they've got all kinds of evidence, well, I'm clearly changing my mind. Like I'm not stuck in some kind of position here. I'm not like, oh, you know, it's like I'm basing it only on what we know. And that includes all of us. And I'm not counting everybody speculating about what they think they know. I'm only talking about what we do know, because that's all I can go on.
So Moon Girl channel, yes, RA could hire someone else from Baldwin and Rossi's office. And then as far as stepping in to help him, they would be able to help in the background is what I would assume. And I'm going off some of personal knowledge from when I was removed on the case that Bob was handling. And I actually continued my trial that I was in Illinois because they needed me to come and help, like, but not in the courtroom. So I wasn't allowed to do anything in the courtroom.
Well, he allowed you to sit in the wall of the court, but you couldn't sit at counsel table, if you recall.
Well, that doesn't. I just meant I wasn't allowed to do anything as a lawyer.
Oh, yeah, no question. Yeah, what bullshit. Christy Z, question: if Rosie never formally withdrew, which I think is 100% accurate, and is going pro bono as a private attorney, how can the judge make him use the public defenders she chooses? It's an amazing question. It's an amazing question, Christy. And, you know, her position, the judge's position at this point is that he did withdraw, despite the fact.
But also she's relying on this. I found them to be, what was it? More like super negligent, grossly negligent.
Grossly negligent, right? Which is insane, because Rosie didn't do anything. Like, even if you're one of the people that thinks that Baldwin was grossly negligent because this happened on his watch, and I got into a really long conversation again with David Hennessy about the reality of private defense attorneys in their war rooms in terms of how they're preparing for a trial like this. You're not neatly putting things away every day. You have a war room where typically you have corkboard and stuff stuck all over the place. You've got things spread out all over tables. And like, that's just how you prepare for a trial like this. You're not cleaning that up on a daily basis, you know, and they offered remedial measures. Like Baldwin can't control that this scumbag like crept in there and took pictures.
But like you said, Rossi, there was really no allegations of gross negligence.
None whatsoever. They have two separate offices. Like, how whatever happened with Baldwin got glommed onto Rossi's insane. Shouldn't have happened. Megan Z, another question. Can Judge Diener be subpoenaed by the defense? I would love to know what he knows. I mean,
I don't know what this is about. So give me some background.
Well, Diener was the original judge that was assigned to the case. He's a Carroll County judge. He also happens to be the judge that signed the warrants, the early warrants. And, you know, I mean, he knew stuff. Or
he recused himself, you mean?
Why? Right. He he quoted like that the anticipated bloodlust, which he was not wrong with this case, that he felt like he was not going to be prepared to handle the matter. So he stepped out. I always found that to be questionable, that he had the ability to be able to do that, but he did it nonetheless.
He can't really be subpoenaed into court because they don't know what he knows, so they can't even show that it's relevant.
Right.
And hauling a judge anywhere is pretty difficult, and
it's tough.
Go ahead, Janie Lane.
Okay, Janie Lane, not allowing him to take part in the initial hearing on the 19th makes it null and void anyway, right? So are you talking about Richard Allen, or are you talking about, I'm assuming you're talking about Richard Allen. I would argue yes. I don't know how you conduct anything that's removing anybody from anything without having the defendant present in the courtroom, being made aware of what was going on and being told what's going on. So I would say yes. Whether the Supreme Court of Indiana is going to agree, we shall see. Pat May, welcome back. What state officials should be doing investigations into these allegations of misconduct?
So they did mention some, like the ombudsman office. If we're talking about those, like allegations about the prison, there's like the ombudsman's office, and then I don't know. I mean, it could be who else would be, if there's an internal affairs division, but I don't think that, small police agencies don't have
I mean,
them.
we talked about the ACLU, but I don't know if they have an investigative arm. Like I know in terms of the prisons, it's the ombudsman that goes in and like really investigates allegations like that, where you've got allegations of misconduct by law enforcement. It's a different story. I mean, typically it's going to be, somebody in internal affairs within that department, and I don't know that exists. It's a good question. And I don't know the answer because of the size of the county and the size of these departments. It's like, these are not huge agencies that are going to have, built-in internal affairs that are overseeing what's going on and that handle complaints about misconduct. So it's a good question. And frankly, Pat, I do not know the answer. I apologize.
And Dawn Burke is
150
generous. Yeah.
I mean, so far, incredibly generous. That's unbelievable. Thank you so much, Dawn. That is amazing. And how would I feel being innocent?
She's telling the masses, like, how would you feel being innocent, being in RA's place? And it's true. Some people who are more, prosecution oriented or believe that he's guilty just do not leave space open, one, for the concept of you're innocent until proven guilty, but for the actual possibility that somebody might be innocent. And it's shocking in this day and age, given how many people have been proved innocent by DNA and changes in science and, every other thing under the sun. I mean, there are countless wrongful convictions where the person has literally proved that they are actually innocent.
And I'm gonna pile on to Dawn Burke's sentiment there, and imagine being innocent in jail, and then you have the two guys that are fighting their asses off stripped away from you with no control over it. How would you feel about that? I wouldn't feel very good about it.
And no control. Yeah.
Lead with love, $10 holla. Thank you very much.
She's been very generous this evening as well.
She has been very, very generous. Thank you so much. Small town rampart scandal. LA officers and gangs work together. I'll have to check that one out. Sounds like a good
Netflix
podcast
series.
Yeah, or
podcast. Yeah.
Season. Yeah.
Wow. Here we go again.
Jeez, like just Okay, going back to school, don't know if I can change anything. I know I can change something. Dawn, I'm 53. Samesies, you could definitely change something. You're young. You're young. Trust me.
Yeah.
There's not
I mean,
too
we
much.
like to think we can change something, but I'm always the one that reminds people, like, if you're going into the law to give voice to the voiceless and power to the powerless, such as myself, it can be very draining when you realize what little you can do, but you can implement change, and there are things that you can do. It's just a never-ending
It's
thing of
tough.
things that need to be done.
And it's, I don't want to give anybody the misimpression. It is gut punch after gut punch after gut punch, and it is incredibly difficult to affect change in the system. We realized it very early on in our practice. It was like the first day. It was like really takes the wind out of your sails when you realize that the machine just grinds you up and spits you out. True Compass Podcast, $2 holla. Thank you, Shay. This is my girl. We love Shay. She's got a brand new pod out, which I love. I love it so much that she interviewed me, and I think it's her most, I don't think she's dropped another episode since. So that one should be the most recent in her feed. And it's a great interview. And she really gets into a lot of really interesting things. She's super thoughtful about her questions, and she's trying to come from angles that are not beaten like dead horses. So I highly recommend you check it out. It was a great interview. And she asked me a lot of really interesting questions that I tried to answer as fully and honestly as I could. So thanks. Thank you, Shay.
So Ariel wants to know why the federal rules of civil sorry. Why the federal rules of civil procedure, can I speak this evening, matter though? And first of all, I mean, it's a good point, because first of all, this is not federal court. But sometimes the civil rules do apply in criminal procedure. It just depends, on the rule. But focusing on the federal rules when you're in a state court is a stretch. It's a reach. It shows that you don't really have much. It's definitely not a good argument to be making.
Yeah, and I mean that was kind of the argument that was made as to some of the filings by the defense, like in terms of the Sixth Amendment issue, because it's basically a novel issue. There have not been many judges that have pulled private counsel, if any, off the case. So there's not much case law out there, but one of the criticisms is that they were using non-binding decisions. They were using just what they would consider to be cases that are, can be considered in terms of an analysis, but they're not
persuasive arguments, right?
Right.
What they call persuasive case law, like I was saying, it's non-binding. It's not on point, like he mentioned before, or it's from a different, jurisdiction, or sometimes even the same court. Like in Illinois, we've got multiple circuits within Illinois, or districts. So if it's not in that district, the appellate court, doesn't consider it as binding. Travis Williamson has got a lighthearted.
So how does it work in the Mata household? The Bears punt a lot. True story. A whole lot. Eagles, not so much. Who's the expert on punting? Obviously me. And on top of that, Allison hates football. So those two things combined.
I don't hate it.
You hate it. You hate it.
You don't even let me ask questions. I like to understand the rules.
I've tried to explain the rules to you. You don't.
I'm pretty much got a lot of the rules now. Your father did a much better job than you.
Yellow Jacket. Bob and Allie, what are your predictions? Lay it on us. What do you think?
I mean, I wholeheartedly hope that his lawyers, if his new lawyers are doing their duty, are doing their duty to make sure that he's got a fair trial, to make sure that, the Constitution is protected, they should be raising two arguments. One, that his lawyers need to be, admitted to represent him. And two, that there should be a change in judge. And them not doing it shows they are not doing their duty. That's my position. And I really hope that the motion to appoint or to let Rossi and Baldwin back in the case, it should be granted. And it's my hope that it does, and that somebody presents it to the court in a manner that it can't be. And I still think that they should. So when Kara was on, because my position's like, all right, file an interlocutory appeal. Like, you had one of the biggest, most serious constitutional error take place. They denied you your right to counsel of choice, private pro bono counsel of choice. But she says in Indiana that might not be granted. I would definitely be trying to file that, but it would, take his lawyers trying to address the issue. And considering they haven't even taken it up in the lower court, I can't imagine them bringing an interlocutory appeal.
Yeah.
And Mark against Adri, is it Adri?
Wait, you didn't let me predict.
Oh, I'm so sorry.
Wow.
Let me just cut you off again.
Okay. So I'm worried. I have a feeling that I have a feeling they're going to keep it status quo. I'm extremely concerned. But what I do predict is, if in fact they keep it status quo, I think that there will be a hero that'll ride in on a black stallion, private pro bono counsel, and will enter their appearance on. I think that somebody will step up if Baldwin and Rosie are not reinstated back to the case. My prediction will be that another attorney, another prominent attorney, will roll in there and enter their appearance on behalf of Rick Allen. That's what I predict. I want Brad and Andy back. Like, I hope that's what happens. I'm just fearing, because there's so much politics involved. Like, you just cannot move out. Aside from the law, there's this intertwining of politics that is always omnipresent in stuff like this. And, just removing her from the case, because prior to this, I mean, she was well respected. She just was. You can't undo what her reputation has been. She's been a judge for a long time. And she lost control of this one, but I hope I'm wrong. I really do. But my ultimate prediction is that ultimately Scremin and Labreda will not be representing him at trial. Dark Arts by Adrienne. So you think it's Adrienne or Adrienne? Whichever one.
She makes a very good point of a way to circumvent.
I saw it. What do you think? I mean, it sounds legit.
She says, what about GoFundMe for Kathy Allen? I don't think there could be any bar against that. No one could prevent it. So I think that would absolutely work. I think so too.
I
don't know that Richard Allen knows who he would even hire, though.
Well,
does he have another lawyer in mind?
We can help him out with that. We can figure that out. I'd probably push for Eskew, to be honest with you. He's a pretty good criminal defense lawyer in Indy. Or I'd rag the shit out of Hennessy.
Well, and that leads into Nico's question. I was just going to say that. You didn't ask him when you had him?
I did. Well, he's retiring. His last case is a triple homicide, and he's calling it. I think he could be convinced, but we'll see.
So read Nico's question, which you basically just answered.
Okay. Nico, question: if Baldwin and Rosie are not reinstated, will Hennessy take on RA's case pro bono? Maybe not. Like I said, like, y'all listen to that interview. He's an amazing dude. And we went for about an hour strong. Per usual, I probably talked too much, but he got plenty in to say. And we talked about a lot of stuff. It was a really interesting interview from a couple of old head, criminal defense attorneys. Yellow Jacket. How often do public defenders get a high profile case with a client they 100% believe is innocent? How common is this? Very rare. I would hazard to guess. Very, very rare. And again, like, that's why I keep saying it all the time when I keep saying that thing, that this is what it looks like when you've got attorneys, and I don't care if it's private or public defender. It's rare to get an innocent client. I mean, a vast majority of the time, law enforcement gets it right. And then the equation for the defense attorney becomes, did law enforcement violate the Constitution in order to make their case? If they didn't, and they got the evidence, the guy's going down.
And it's negotiating a fair sentence for the person.
It changed our job. Right.
Try to get them to take into account all the mitigating factors and social factors and, whatever the case may be, and making sure they're not overcharged. And I know I've said this before on different lives, but so many clients say to me, well, how come they're charging me with 4 things for this one thing that I did? And I'm like, well, they're just charging it every which way that they can. Sometimes it's because they think that the jury is going to be like, well, we'll let him off on all of these and find him guilty on this, like a mental thing for the jury to be like, just, taking their chances on which way under the statute they can prove it up or they can do it. But yeah, it's definitely not.
And remember, Rosie and Baldwin are not really public defenders. They were appointed to the case, but they're not. They're private counsel. Like, no public defender on the planet. And I wish Shay was here, because I'd ask him if Shay has the time to. Shay Hughes is a PD in Indiana, real bright guy. I'd ask him, I'm like, yo, dude, like, would you have time to write a 136-page memo on one of your clients?
I think on cases like this, though, they do usually use like senior PDs, and they way, way, way reduce their caseload, like significantly. And especially when they have one of these.
Yeah, they would have to, I would think, because I mean, look, and this isn't a death penalty case. It's not death. But remember, they're bringing him on felony murder. Like, the bar for them getting conviction on this case is super low. I mean, they do not have to prove that he killed anybody. It's a very scary case for a lot of reasons. Jana Island, $1 holler 2 times. So I'm going to call it a $2 holler. Thank you. Oh my God. Dawn Burke. Dawn Burke has just gone above and beyond tonight. Dawn,
it's like
you're unbelievable.
20 or something.
Holy smokes. Like, you paid for our vacation, Dawn. You're just, if only YouTube didn't take all the money.
No, don't tell people that. They won't want to give us any.
Well, no, I mean, like, what I have to do is throw Venmo and like other features in there. So we like.
Wait, do they really take some of this money?
They do. I found out. Yeah.
What? You told me they didn't. Oh, people ignore that.
What do I know? I mean, we definitely get a portion of it, but they take a percentage of it. Hey, starting my classes, can I ask you? I was always said, you can argue because I believe I can help. I will need help on both sides of school. I mean, it depends on what you're trying to do, Dawn. Like, what are you going to school for? You trying to enter this lawyer fray? It's whew. Hope you're ready for it. It's quite a thing. It's quite a thing. Dawn, you've been just incredibly generous. Thank you so much for everybody that's been so generous, not only with your money, but with your time. And it looks like the live was unbelievable.
It was up over 1,000.
I don't know if any of our mods saw some questions that they wanted to throw up. It looks like I wasn't looking at what was going on in the.
We were answering a lot of subscribers' questions. We weren't only doing, so they've been doing a very good job at that.
Good. All right, good.
And did you tell the people when the judges, or retell the people when the judges' response is due on the other petition?
Yes, that is due the 27th of this month. Big day. So after Turkey Day, after Black Friday, let's get ready to roll. And I think that is going to fall on Monday, the Monday following Thanksgiving. So it'll be exciting.
So let me ask you this. So obviously, like we all saw in this response, the judge is like, well, they didn't need to go this route, right? Because they could have gone this route, and this route. Like I'm assuming they're going to avoid that answer in the second petition because they don't want to give a roadmap to the defense of all the things that they could do to accomplish this same goal they're trying to accomplish.
Yeah.
Be interesting to see if they do that in this response.
Yeah, no question. And Megan threw in a $2 holler. Who do we call email to make noise? We have the numbers. I agree. I know there's a petition that's been floating around. I think that when we're going to really see like what kind of numbers we have is when the Supreme Court of Indiana rules on this. I think.
Or the second one of these.
And I know that there's a groundswell that's going on the 27th. I'd be remiss if I didn't mention that. I believe it's on the steps of the Supreme Court of Indiana that they're hoping to generate a big crowd out there, trying to show support for Richard Allen getting a fair trial and for the Constitution. And I know that's happening out there, and I hope that there's a big crowd out there. I might be out there, so we'll see how it plays out. So that's one thing we can do. We just look. We have voices out here. I know that the defense has heard me because I've heard from them that they've heard me. Championing their cause. So they hear us. When it gets up to the people in power, we just have to hope that they're hearing us too. I think that we just have to keep talking. We have to keep the dialogue going, and we have to keep making our voices heard. And then we just have to hope that there's some people out there that are listening. So the one thing that we can't do is shut it down and quietly watch as this thing develops. So, I think that's something that we just have to continue to push forward. So, all right, we're going to call it. We do want to.
Ariel gave Dawn Burke like a little tip here. It sounds like that she probably is going to law school, so she's suggesting she network and go to professors' office hours. And if it is law school, I'm not sure study groups, but that's good for any sort of advanced learning is to get in like with a small group that you study together with. It makes studying not only easier, but you get all those, questions and thoughts bouncing off of each other. If you're going to law school and your school's got clinics, taking part in those kind of things are always good. And yeah. Stuff like that.
Yeah. For certain. All right. So first and foremost, I want to thank all of our mods, babe. Mandy, thank you so much. You are always on the money. Law Nerd Amber, thank you very much for modding. And Law Nerd Amber, Allie, in case you don't know, has been timestamping our lives, which means that she goes through, she rewatches them, and she timestamps them with links for certain points throughout the live where she gives what subject matter we're talking about. So if people have limited time and they can't sit around for an hour and 2 hours.
2 hours and 13 minutes.
So thank you so much for doing that, Law Nerd Amber, because people massively appreciate that. Let's see, who else do we have in here? Carly, I know, is in here. Thank you so much, Carly, for everything that you do. And for any of my other mods, I don't know if you're in here. I don't know if Jay, I don't know if Dan, I don't know if Steve are in here.
I saw Jay at some point, but
thank you. I don't know if Shan's in here. Shan, I think, has a real job, so she might be sleeping, but thank you. Sandy, if you're in here, thank you. I can't go up on the scroll to know, but any of my mods, Fofa, thank you. I see you're in here. Thank you for modding. Missy Mayhem, if you're in here, thank you. And to all my mods, thank you so much for doing this. It makes such a huge difference. And hopefully the chat was cool in the gang tonight. We always want to hope that it's cool in the gang. And for y'all on the East Coast, which I know there's a ton of Indiana folk in here and probably other East Coasters, thank you for staying up till midnight. Sorry to keep you up so late. You know how we go, though. We're not.
Don't forget, when you close out the chat, you can see the thumbs up or thumbs down. It's your choice, but give us thumbs up. We'd appreciate that as well. And it helps get the feed going. Algorithm. And as Bob always reminds everybody, Defense Diaries, the podcast, check it out, listen to it. It is definitely not, obviously just these lives, although that is going to eventually end up on the feed as well. But there's tons of stuff. We did in-depth coverage of Lori Vallow, extremely in-depth coverage that was amazing.
That trial, it was amazing, and Allison did so much work on that. And if you were interested, that case was fascinating. It was disgusting and fascinating all at the same time. But we really dove deep into that. We are currently in the middle of Avery, and we're covering that case like no one has ever covered it anywhere on any. I don't care who they are. And it's going to probably run 40 episodes. Like, if you know anything about my
seriously, podcast, I've been telling him, what are we doing? This is going to be forever because we've gotten through 10% of the police reports at this point.
It takes as long as it takes. And that's my position on it. So we're trying, we're on the fence on that one. It's like this case, I do have a bias in terms of I'm very biased towards the Constitution. That's who I'm biased. When it comes to the Constitution, I'm always biased towards the Constitution. And I think that there's been violations of the Constitution that have taken place right before our very eyes. So
what season is Avery when you go on the feed under?
I believe it's 7. I think it's 7, season 7 of.
So what Darren tried to do is take all the cases that we've covered more than just a one-off here or one-off there and put it in its own season because we're still trying to figure out the best way to handle the feed. So it's not necessarily the most, just going to the most recent season. It's to kind of look through the seasons and see what topic is being covered. And, and there's multiple.
Travis, we got you, man. We got one in the can last night. I'm tracking Allie down after this because now that her voice is all warmed up, we're gonna pound another one out before we go on. So, like I said, we've got there's an Avery in the can. I've got the David Hennessy interview in the can. Those are in the hands of Darren at this point. And I want to have a Garcia in the can before I leave and one more Avery. So,
well, we're doing Avery as soon as we get off this. So
that's right.
The man is working me. I can tell you that much.
I know. But we want to keep y'all. And I swear to y'all, the pod's a different thing. Just dig into the pod if you haven't. We really get into it, and we did their super deep dives. They're different because we're both defense attorneys. So you're getting a unique, different perspective. And we happen to know what the hell we're talking about. So, all right, we love you so much for hanging with us. And just know this, without y'all, I'd just be an old man.
Talking about a lot of cases.
Damn, Skippy. See ya. Just facts, baby.